Sometimes I'm embarrassed for other people. That is the case when it comes to Judge Robert Jensen Bruen, a federal district court judge in Washington state who just issued a decision refusing to enjoin Washington state's quote-unquote assault weapon ban. I can't believe how poorly this decision that he wrote is reasoned and how it improperly applies relevant Supreme Court precedent. Stay tuned. You're not going to believe this when we go through it. Hey folks, I'm Mark Smith, host of the Four Box of Don, a proud American gun and a constitutional attorney, member of the United States Supreme Court Bar, and author of the best-selling new book, Disarmed: What the Ukraine War Teaches Americans About the Right to Bear Arms. Check it out on Amazon.com. All right, folks. So, I read the opinion from Federal District Court Judge Robert Jensen Bruen. Judge Bruen issued a 17-page decision refusing to enjoin, refusing to grant a preliminary injunction against Washington state's new quote-unquote assault weapon ban, which of course just deals with semi-automatic rifles and other related things. Now, if you ever remember those cartoon shows that you watched when you were a kid, and like Wile E. Coyote would walk through a yard and he literally would step on the prongs of every single rake, and when he stepped on those rake prongs, they'd come up and hit him in the forehead repeatedly, and he managed to step on every single rake in the farmyard. Well, I feel like that's the best way to describe this opinion by Judge Bruen, because it made so many fundamental errors of law, and fact for that matter, that I lost track counting them. So let's just begin from the start. As you know, if you're dealing with an arms ban case, meaning the ban of any kind of arm, including semi-automatic rifles or pistols or any of this stuff, the test in a Second Amendment case for an arms ban has already been decided and set forth. By looking at the text and the history, the United States Supreme Court in Heller in 2008 created the in common use test that said that if an arm is in common use by Americans for lawful purposes, it cannot be banned, period, full stop. That's the full extent of it. Now, before we get into the details of the problems, of which there are countless when it comes to Judge Bryan's opinion, I'm going to read language from the United States Supreme Court in Heller. No, I'm going to take that back. This is from Heller, yes, but it's also set forth in Nysurpa versus Bruen, quoting and discussing Heller and quoting and discussing, of course, the 2016 decision in Caetano, both of which dealt with arms ban cases. Heller was a handgun ban case, and Caetano was a stun gun ban case. Here is what Nysurpa versus Bruen said in the summer of 2022. Now, for those of you non-lawyers out there, I'm going to read this to you from the United States Supreme Court, and then I'm going to ask you whether or not you think this allows a judge, or requires actually a lower court judge, to enjoin a law that bans an arm, such as semi-automatic rifles. Here's what the Supreme Court says, quote, "We have already recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to arms does not apply only to those arms in existence in the 18th century, citing to Heller. Just as the First Amendment protects modern forms of communications, and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Thus, even though the Second Amendment's definition of arms is fixed according to the historical understanding, that general definition covers modern instruments that facilitate arms self-defense. It then cites to Caetano versus Massachusetts, referring to stun guns. Now, modern arms, right, that are used by Americans for lawful purposes are protected by the Second Amendment. How hard is this? That was the Heller standard, repeated by Nysurpa versus Bruen and beyond. So what does Judge Bruen do here? Well, the first thing he does is he doesn't apply this test. He doesn't apply the in common use test. He starts off with trying to conflate the text of the Second Amendment with the in common use test. Remember, he says specifically that the text of the Second Amendment requires for it to be met by the pro-Second Amendment plaintiffs. It somehow requires that these weapons be in common use. Well, no, that's not true, because the Supreme Court in Heller defines arms to mean basically anything that can be used offensively or defensively, including body armor. That's not Mark Smith. That's not the Four Boxes Diner. That's not the Old Testament. It's the United States Supreme Court in Heller in a binding decision that is still good law, that has to be applied by inferior courts, such as Judge Bruen in Washington State. So, of course, the first thing is, rather than apply the definition of an arm, which is anything that can be used offensively or defensively, he tries to conflate it with in common use. But this is clearly wrong, because, of course, the in common use test is about, are Americans using these for commonly used, i.e. possessed? Keep in mind, the second mistake that Judge Bruen makes is that he tries to say that the plaintiffs have the burden to submit to court now that these arms that are being banned are in common use. But that's not true, because the standard is that once the text of the Second Amendment is implicated, which obviously if you're banning arms, that obviously implicates the text of the right of the people to keep their arms shall not be infringed is implicated. So once it's implicated, what happens? We know what happens. The burden shifts to whom? The burden shifts to the government to show that their law is constitutional. No different than if somebody accuses me of committing a crime, the burden is on the government to show beyond a reasonable doubt that I committed the crime. The burden is on the government to act. I don't have to do anything. I can sit in court when somebody accuses me of a crime and literally look out the window and do nothing. The burden is on the government to show that I committed the crime. I don't have to do anything. Likewise, by analogy, it's the same thing. Once the text of the Second Amendment is implicated, which obviously if you're banning a type of arm, the Second Amendment is clearly implicated. That's a no-brainer. The burden then shifts to the government. And in the arms ban case, what is that burden that the government has to bear? The government has to come forth to prove that the arms that they want to ban are not in common use. The burden is on the government to show something's not in common use. It's not on the Second Amendment plaintiffs to show that something is in common use. The burden is on the government to show not in common use. Of course, when you're dealing with semi-automatic rifles, it's a no-brainer it's in common use. They're totally understood to be in common use by none other than the ATF says the AR-15s are the most common and popular rifle in the United States. That's the ATF itself, not to mention all the countless other evidence that these rifles are ubiquitous. We know they're ubiquitous because the anti-gunners completely complain, and all these politicians that ban anti-gun laws are complaining there's too many guns in America, which means by definition they're in common use. Hello, hello. How hard is this? All right, well, let's continue on. So you saw the standard. The text has obviously been satisfied here, and that's obviously these weapons are in common use. And then, of course, again, the judge says, Judge Bruen says, hey, the plaintiffs have to come forth with this evidence. No, we don't. No, you don't, right? The government has to do so, not the Second Amendment community. So that's the next mistake he made. To give further proof, again, don't trust me. Read the Supreme Court precedent that you're supposed to read if you're an inferior court. And by inferior court, I don't necessarily mean your skill set. Under Article 3 of the United States Constitution, you have the Supreme Court, and then you have all other courts are inferior courts. That's not me, that's U.S. Constitution. That's what these judges are, inferior courts, relative to the Supreme Court. So if the Supreme Court says yes, it's yes for all the courts in that system. Now, here's the thing. Let's talk about, do the plaintiffs have the burden to come forth with evidence that these arms that are being banned in one way or another in Washington State are in common use? The answer is obviously no. Why do we know that? Well, how hard is this? Let's look at the Supreme Court's decisions. Let's start in 2008 with Heller. Heller was decided on a motion to dismiss, which meant that Dick Heller and the plaintiffs in Heller brought a complaint. There was a motion to dismiss by the government, which was granted. That was it. There was no trial. There were no experts. There was no testimony about guns being good or bad, or guns shooting this many rounds, or how many guns there were in America. Nothing. None of this. Nevertheless, the U.S. Supreme Court in Heller was able to say, no brain, right, that whatever we can say about handguns, or whatever reason people own handguns, they are the most popular weapon for self-defense in America. They're very popular, and therefore they're in common use, and therefore they're protected. No trial, no evidence, nothing. And yet the Supreme Court was able to find that handguns are in common use and cannot be banned in Heller. Caetano, same thing. Miss Caetano was arrested for having a stun gun. Massachusetts law banned the possession of stun gun. She had a stun gun. She basically, she had a short trial and was found guilty. There was no testimony or evidence at trial about how many times people use stun guns, how many times they pull the trigger, how many people have saved their lives with stun guns. None of this stuff was presented at the trial court in Caetano. And yet the U.S. Supreme Court was able to say that stun guns, right, basically to say that the in common use test is the relevant standard. Modern day firearms and modern day arms are protected under the Second Amendment. And of course, in the Alito concurrence, stun guns were deemed to be in common use because 200,000 people own these things. Again, no trial, no evidence, nothing like that. It's not needed. And of course, even in Bruen, that whole decision in Nysurper versus Bruen was made again on the motion to dismiss. There was no testimony about, guns being used for self-defense, people pulling triggers, any of this stuff. It was decided on motion to dismiss. So all of a sudden, when these courts want to rule against the Second Amendment, they want all this evidence. And yet the Supreme Court didn't require any of this evidence in all those cases in finding that handguns, for example, are protected arms under the Second Amendment. So what gives? Obviously, we know what gives is these lower court judges are not reading the Supreme Court. They can't understand what the Supreme Court opinions are saying, or something else is going wrong, but they're clearly not following what the Supreme Court has taught yet again. The next mistake that Judge Bruen makes here is he says, quote, the proponents of the assault weapon ban have pointed to evidence that assault weapons are rarely used for self-defense. That's what he says. So what? It's totally irrelevant because, again, the possession of the arms is in common use. I ask you, Judge Bruen, and your law clerk, the following question. When you read Heller, can you point to me the passage of the majority opinion that talks about how many times a gun is fired, how many times it's used in self-defense, or anything like that? You can't. It's not there because the Supreme Court didn't care. It wasn't relevant. The only thing that mattered is that arms are in common use, i.e. they're possessed by Americans for lawful purposes. That makes them in common use. It doesn't matter how often they're used. Remember, by definition, the Second Amendment is essentially always a rare event in the sense that you hope you go through life never having to pull a trigger to shoot someone. But that's not the purpose of it. The purpose of it is though you have the gun, it can use it for various lawful purposes, including but not limited to for self-defense. And again, if you go back to Heller, there's no discussion of how many rounds are fired or anything like that because it's not relevant. It's only about possession. To further reaffirm this, take a look at the concurrence from Justice Alito and Caetano. Again, the mere fact that 200,000 stun guns were owned or possessed by Americans, that was enough for in common use from Justice Alito in the concurrence at Caetano. It doesn't matter because the mere possession of a firearm is using the firearm. A cop simply holding on to that gun in his holster is using the gun. A gun on a nightstand is using the gun. A gun in the closet is using the gun. It's because the idea is got to be there in anticipation of use, in anticipation of self-defense use or whatever the reason is. But again, the Supreme Court has set the standard. It's all about mere possession. There's no suggestion in any of the Supreme Court precedent that it's anything beyond that. Now, remember, the other mistake that Judge Bruen has made and other courts are duped, in my view, by virtue of anti-gun arguments, is they're trying to conflate the in common use test with commonly used for self-defense. But that's not the standard because, again, there's nothing in the opinions that say that. The only thing that the anti-gunners latch onto is they try to argue that because Nysurper versus Bruen in 2022 talked all about self-defense, they try to conflate the Heller standard of in common use with the references to self-defense in Bruen to say, see, it's in common use for self-defense. But that's not true. The only reason why the U.S. Supreme Court in Nysurper versus Bruen talks a lot about self-defense is, of course, because the issue in Bruen itself was whether or not those plaintiffs had a right to bear arms outside the home for the purposes of self-defense because they were already allowed to, under New York law at the time, to carry their gun outside the home for all sorts of other purposes, but they weren't allowed to carry the gun outside the home in New York for the purpose of self-defense. That's why the Supreme Court spent all their time in Bruen talking about self-defense, not because they were modifying the Heller standard in a gun ban case, because Bruen was not a gun ban case, right? It was whether or not the individuals, plaintiffs, could carry a gun outside the home for self-defense. That's why they talked about self-defense in Bruen, had nothing to do with a gun ban case. Nevertheless, here you have Judge Bruen trying to conflate the two cases and the two standards, which suggests to me that he hasn't read these cases, or if he's read them, he hasn't understood them or hasn't read them carefully. That seems to be the outcome based upon his opinion. Again, maybe he understands everything completely and I got this completely wrong, but by my review of his opinion, let's just say I'm not impressed. The next error that Judge Bruen gets wrong is, again, he confuses the Heller methodology with the in common use test. Now, what I want to do is explain this quite simply. The way to understand the relationship between Heller on the one hand and Bruen on the other hand is quite simple. Heller, in 2008, the Supreme Court took the text of the Second Amendment and defined arms, for example, as anything that can be used offensively or defensively, and they also defined the right to keep as to possess, the right to bear as to carry outside the home, and so on and so on, okay? So the Supreme Court defined the textual language in Heller to begin with. And then they go on and they say, okay, then we're going to look to the historical evidence to see if there's any restrictions on the right to keep and bear arms. And what they said, and why they said you cannot ban handguns because they're in common use by Americans for lawful purposes, because if you look at the relevant historical evidence, that one thing was certainly clear, 100% clear, according to the Supreme Court in the Heller case, was that if an arm was in common use, it's protected, period, full stop. That's it. That's all that has to be shown. If it's in common use, it's game over. The citizens win and the gun ban falls away. Now, there may be other ways that arms can be protected, but for the purposes of things like magazines that hold more than 10 rounds or semi-automatic rifles in America today, we don't have to worry about anything. It's in common use and we win, which we should win all these cases because, again, that's what Heller taught us. Now, of course, if you're not following Heller and you're just not paying attention as far as I'm concerned, or you are conveniently trying not to pay attention because you don't like the result it gives rise to. And the last point I want to make of why we know that Judge Bruen has gone off the rails on this opinion is that if you take a look at his page 13 where he sums it up, he basically talks and does something he's completely not allowed to do. Remember, Heller and NYSERDA versus Bruen say there's no interest balancing. You can't say guns are good versus guns are bad. You can't get into tiers of scrutiny. And yet, nevertheless, here you have Judge Bruen, despite that clear declaration and order from the U.S. Supreme Court, here's what he writes. The plaintiffs wish to buy or sell more assault weapons. Considering the exceptional dangerousness of these weapons, which is totally irrelevant because they're in common use, it doesn't matter, right? The public interest in the regulation by the state outweighs the plaintiff's desire to purchase more assault weapons. You see what I'm saying? He's balancing the interest of the state against the rights of the individuals. The Supreme Court says you can't do that. And here you have Judge Bruen on page 13 of his opinion doing the exact thing you're not allowed to do. It's like, what's wrong with this judge? Does he not read? Or did he not even try to get this law right? What is wrong with him? It's almost like he just read what the anti-gun brief said and followed it. Now, Judge Bruen then goes on to say, believe it or not, in light of the recent mass deaths caused by assailants using assault weapons, it is appropriate for governmental bodies to find ways to protect the public from dangerous weapons within the limits of the Second Amendment. Public opinion is apparently strongly divided between the plaintiffs and defendants, between those who wish unfettered access to assault weapons and those who seek to curtail that access for public protection. Totally irrelevant. Totally irrelevant. What is wrong with Judge Bruen? Can he not read? Does he not understand that when you read NYSERDA versus Bruen, it makes it completely clear that interest balancing between the good of guns and the bad of guns is totally unacceptable because we do not measure our rights as Americans by virtue of how they can be misused by miscreants and criminals. That was explained in Heller and again in Bruen for the purposes of inferior court judges like Judge Bruen to try to read and get it right. The only explanation for this is he can't understand it or is not trying. Okay? The last thing I want to say on this point, of course, is that his only possible excuse, which is not an excuse, is that he is somehow conflating substantive Second Amendment law as given to us by the Supreme Court in Heller, Caetano, McDonald, and Bruen with the procedural rules associated with the balance of the equities. But that is clearly not appropriate either. Because when you are dealing with a constitutional right, this is not a commercial case that Judge Bruen is deciding. This is a constitutional case where allowing a single day of a violation of a constitutional right, a fundamental constitutional right, which the Supreme Court has said is on par with all the other fundamental rights, including the right to life, mind you. A single day deprivation of a constitutional right that's fundamental, such as the Second Amendment, is irreparable harm. And there is no interest on the other side in favor of the government that can be balanced against it. That's not Mark Smith. That is black letter Supreme Court federal law on the procedural issues associated with applying the standards for motions for injunctive relief, including a motion for a preliminary injunction, which Judge Bruen refused to apply here. So to sum up, I think this decision was, shall we say, in the most polite way possible, weak tea, and not worthy of a federal court decision, in my opinion. Nevertheless, there is an opportunity for Judge Bruen to get it right going forward because the case will continue. And let us hope that perhaps in the next chance he gets to take a crack at making a decision involving the Second Amendment in this case, or perhaps in others, he will have read the Supreme Court precedent more carefully and will get it right in the future. Okay, folks, hope you learned a little bit something here today. I'll keep you apprised of this case. And by the way, the name of this case of Hartford versus Ferguson. I'll give you further updates on this as the case moves forward. And if you haven't subscribed to the Four Boxes Diner, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.